if you need to be at that stage where you're thinking about being an LLC or an S corporation, the better question to ask yourself is, are you a real startup? And it takes time to change this. What you don't want to do is, Sean's going, you know what, I want to invest in your company. And you're like, wait, crap, I have to change my corporate structure from an LLC to something, to a Delaware C-Corporation, right? You don't want to get stuck in that kind of a slowdown. It's just, if it takes too long, yeah. Right, Sean might be in Norway, swinging Viking axes or something. So you never know. There's a lot of stuff out there. There's a lot of lawyers you can hire, but use the standard terms. Use the standard Silicon Valley forms. Yes? Yeah, no, why is the Delaware C-Corporation superior? It's not necessarily superior, but it's efficient. All the venture capital firms are very used to it, and it's just a very tried and true vehicle. So,
what makes it different to the other? Just like very, very briefly.
To which ones?
To the S and to the LLC.
The point that I will make is that most venture funds will not invest in S corporation or LLC because it's a different structure that has pass-through implications. So don't want to dive super deep into that, but venture funds have their own investors, so right, they can't get hit with those tax pass-through issues. So that's going to be one of
only tax.
There's a lot of other considerations, but yeah, if you're trying to squeak by with something that's not a Delaware C-Corporation, again, the question is, are you a real startup at that stage? Use the standard terms. I'll talk a little bit about this. Rob will probably talk a little bit more about this. But what you don't want to do is you don't want to get fancy or creative or outsmart yourselves. We actually, Clerky, again, as Sean mentioned, you can set up your Delaware C-Corporation. We have forms for all of your founders, shares, issuances, and later on we have forms for issuing options to your employees and even doing fundraising. So those are all things you can do online. You may wish to. Our forms and templates are used by major Silicon Valley law firms. Chris and the other founder, and they're startup attorneys in the former lives. And so literally thousands of startups have used our forms as is. That's not to say that you shouldn't have someone look through them just to make sure that they're, as you said, suitable for your company. But if they are, you can take care of it very efficiently. The way I would think of it is, here's all of these things that are available, Mr. Attorney. Tell me if they're okay, and I will go use them, right? Instead of, hey, Mr. Attorney, go spend 5 or 6 hours of your $600 or $700 time and make something up for me, right? There's, as Sean said, there's already kind of real standard forms out there. The KISS, the SAFE, all of these kinds of things, and you just don't want to get creative and outsmart yourself. There was a point at the beginning, lawyers are basically people that code in the English language. Well, if you don't know how to code in the English language like a lawyer and you go start tweaking stuff, well, what happens? Things could have very unintended consequences or could fall apart for you. And so it's just stay on the rails. Whatever rails those might be, Ruby if that's the case, but stay on the rails. Don't get too fancy. Don't outsmart yourselves. This will really cost you to fix later, and something that we've seen time and again. Actually, it's going to slow you down in fundraising, because Sean, if some company comes to you and they've raised like on 4 different wacky note structures before, you're going to ask, well, what the heck are you doing? Is it even okay to invest in that company? It is legalese, but to your point, okay, there are about 6 or 7 major startup law firms, including Wilson, that do this work. Functionally, they know all the other people's forms. Now, I've been at 4 of these firms. Chris is from one of them. They will get you to the same point, unless you want to start going crazy, doing crazy stuff. They've looked at each other's forms. They do this constantly. So don't think that one law firm is going to give you the forms and they're substantially superior than some other law firms? No, especially at this stage. Absolutely not, right? If they're, I'm sorry? Yeah, sure. Chris, let me know if I miss any, but I mean, Wilson, of course, is one of them. Gunderson Detmer. There's, let's see, there's Fenwick and West. There's Orrick and Harrington. There's Cooley Godward. Goodwin Proctor a little bit. There's actually not a whole lot of firms that do this on that level that are really specialized. And as I said, they are very familiar with each other's forms. Yeah. Okay, little sidetrack, but let me blitz to the end, and I will open this to questions. So here's one. If you are a lawyer, unless you're actually a startup lawyer, don't try to be your own lawyer. Even if you're a startup lawyer, the question is, is this the best use of my time, or should I be building my company? Sean, I think we've had this a couple times, but people always want to do this, and yeah, it's such a specialized area of law that unless you are actually a startup lawyer, you may miss things. And in kind of following on to my previous point, if you are just staying on the rails, using standard documents, using standard terms, you can get almost to a Series A with some pretty minimal lawyer assistance, right? Okay, just look at this form, tell me it's okay. Okay, I'm just gonna go use the form. You don't need to engage them to do your entire note round. You just don't need to do those things. I'll talk a little bit about that in a bit. And frankly, when you're picking a lawyer, choose wisely, right? There's a lot of people out there who will charge you a lot of money to do the same work as everybody else. Again, functionally speaking, at the level where you're setting up a company and you may need a little bit of advice, if you're going with these guys who are experienced startup lawyers, aside from you liking them and them actually answering your emails, they should be doing the same level quality of work. They really should. You're not going to go to one of these firms because, okay, that lawyer's a genius and I think this other lawyer's not a genius. No, I mean, it's a connection game, right? If they've got the brand, you're paying for the connections. That's what it is. All right, moving on. Oop, that was the other button. Apparently can't use the clicker. Okay, so who's heard of just-in-time manufacturing? Sure, everybody has, right? Well, this is just-in-time legal, which is to say that you want to do things that are necessary, but you don't want to necessarily do things which are not necessary right this moment. So the last question I'll jump to really quick here. If your lawyer says, oh yeah, just do this and do this and do this and do this, the real question you want to ask them is, must we do this now and why? Because there are some things that you can kick the can down the road and you don't necessarily have to do them, especially if you're paying law firm rates for. Break the legal work into chunks. That's right. Don't try and do everything at once, especially going through a startup. We have resources on our FAQs on support.clerky.com. We'll pass this slide deck out. There is an established order of events. Take it slow, do it step by step. You will be okay. Don't try to blitz through this stuff. Don't try to just, I'm just going to do it all at once. Invariably, that's where you end up with problems. Step by step, it's not sexy. Get it done in chunks. So, who owns a car here? I know this is a city, so maybe some people don't own a car. So there's this thing, yeah, exactly, right? It's really expensive. There's this thing called total cost of ownership. You might have looked at car buying websites like Edmunds or something. So it's not just buying the car, right? You have to buy the insurance. You've got to do the oil change. You have to do your 7.5K and then your 15K and then your 30K and 60K service. So what you don't want to assume is, oh, I've paid my lawyer to draft some document and okay, cool, that's all I pay. It's, I paid him $2,000 and that was the end of it. So it's not just that cost. First of all, if you are deviating from the standard documents, that means that every attorney that you ever talk to about those documents or doing diligence needs to figure out what you've done in a custom fashion. That also means that your investors' attorneys have to look at that thing and know what it is you've done. So that's an increased cost over time. There's an increased, as I said, diligence cost. There's an increased cost to when people actually have to go and calculate how these things work. This very broad term called venture math, which I think we may be talking about at the next session. If there's something that doesn't work in your custom documents, or they don't play well with other documents you might need to use, there's always the remediation cost. I think conservatively, if you really do something that's off the rails, even just a few things, you could easily be looking at minimum 3x the amount of lawyer time on that. If you're using standard forms, again, anybody who's an experienced startup attorney, they've looked at this stuff if they're worth any grain of salt. They're familiar with the forms, they're familiar with the standard terms. If they look at a SAFE from YC or a KISS from 500, they know what's in there. They don't have to go, oh, somebody's edited this document. Now I have to read the whole thing to make sure that it actually works, right? If you say, okay, well, here's the standard KISS, haven't edited it, super simple. They run a comparison, look at the terms, done. If you're using any of these financing documents on Clerky, same thing, right? Punch in the terms, done. So, fly coach, it'll get you to where you need to go. You don't need all the amenities of first class. I mean, when you got the Series B or the Series C, maybe you do some complex stuff because it's really a situation where you need it. But especially right now in the beginning, do the standard stuff. It will save you grief. So, super quick on fundraising. I know we're going to have other people go into this. So, as Sean said, fundraising is a momentum game. So, don't get lost in the weeds of, oh my God, I have to optimize for my valuation, or I have to optimize each document with each investor, right? Anything that slows you down from getting that check, you want to think really, really carefully before you even go down that route. Just be really, really guarded with, okay, I've got to push through this. Again, the consistency in terms and documents helps you avoid that overrun on the total cost of ownership. You can imagine, right, if somebody comes to you and says, you know what, I have 10 investors and I want you to give me more money, but each of my 10 previous investors, they invested on a different document with different terms. That 11th investor is going to go, what in the world am I getting into? All right, they're going to ask that question. That's their job to ask that question. Something to consider, especially if you're starting to do, custom document for this investor, custom term for that document, especially if you're from overseas, where I think privacy is a very different issue. This is Silicon Valley. These investors all talk to each other. They all talk to each other. So then the question is going to be, well, wait, how come he got the special treatment and I didn't? Right? So I'm not saying that this is necessarily that you have to do the same thing for every investor, but think very carefully about it before you start doing that. A few notes, we won't go too far into them, but just know that, when you're having money coming in, your board actually has to approve of that. So just one of those things you don't want to forget. And you don't want to forget that, again, this is somewhere where you may need attorneys to help you with, but there are securities compliance issues to think about when you sell securities, including notes, convertible notes, equity, common stock. There are some compliance issues. Just keep that in the back of your mind that, hey, we got to deal with this. I don't want to jump into that because it really could be different per company. Again, I'll open the floor for questions at the end here. So, equity compensation. I am going to guess that many of you, if you're at that place, you will need to hire people. So, just a few kind of hints on staying on the rails. You want to use a stock plan. So what is a stock plan? It's also called an option pool. It's also called a stock option plan. To put it very simply, you take all the shares, right, that you have authorized for your company, and all you're doing is you're saying, okay, I'm going to use a stock plan, a legal document, to carve out a part of that to give to employees, advisors, consultants, et cetera, et cetera, et cetera. Well, why to do that? And why do we say that a stock plan is your startup's best friend? Can be your startup's best friend, because it's elegant. It makes issuing equity or granting equity to your employees, advisors, consultants, et cetera, scalable and efficient. You shouldn't be just giving out, stock to people who aren't founders or really key employees. You bring on a new CTO, okay, then maybe you think about that. But if it's just employees, advisors, consultants, anybody who's a quote-unquote service provider, there's a special legal definition for that. A stock plan is a very elegant way to do it. Just something to keep in mind, might be talked about, I think, in the next session as well, but when you're granting equity from a stock plan, you have to do it at fair market value. There's a lot of, it's frankly a little bit of a blurry area as to when and how exactly this fair market value comes out. But keep in mind that you can't just make something up. You can't just make something up. So, okay, actually, that's about a wrap up here. So, Sean, we have a gift for Galvanize and Adam. So if
I've got another mic here too, so anyone who has questions, I'll pass this around.
Yeah, we're gonna. Sean's got the beard now. I don't know. Yeah, but so if you set up your company through Clerky and you're gonna use 500 KISS documents, when you're finished with your round, just let us know. We'll refund you the charge for that.
Oh,
yeah,
that's cool.
Yeah,
I didn't know about this. This is a surprise.
Oh, we just came up with it just for you guys.
What if they need to incorporate? Can you talk about what you guys do, what other people do, and what is the cost associated with that?
Absolutely. So if you incorporate through Clerky, the initial cost to actually get your company set up is, let me give you a more total cost. It's
give it to me straight. Don't give me the lawyer answer. I want to know.
It's approximately something around $1,200.
Okay.
Yeah.
It's cheap.
And that's actually including all the fees that you would generally be paying to the government and all of those types of things.
So if I went out to a lawyer and market, though, what am I'm paying a little bit more, $2K? That's what I always quote, or no?
I don't know, Chris. I think probably $2,500 to $5,000.
Yeah.
For just an incorporation from a law firm.
Okay. And what is turnarounds? A week? 2 weeks?
To set up a Delaware corporation, like 2 to 3 business days.
2 to 3 business days. Okay.
Yeah.
Pretty quick.
Yeah. To get the initial incorporation, 2 to 3 business days, and the other stuff is not government controlled. So when you've made your decisions, you can finish your documents and you're done, right?
Okay.
Question.
Some questions out there. Yeah. Let's use this.
Yeah.
Once you've incorporated, probably silly questions. You'll have to start filing taxes, right?
Yeah.
Is that true? So that's yearly, right? That you have to do that. Okay. I had a different question actually. So you talked about the lawyers and which lawyers to pick. What do we expect? What is a good rate, like an hourly rate that you would expect for somebody qualified to do setting up of the company?
That is a very. It's a good question. You're talking about the rate per hour per person or the total cost?
Yes, no, the rate per hour. You're picking a lawyer and you ask him, okay, so what's your rate? And he'll say something. And I just wonder, what is the right ballpark that we would want to expect there?
That depends on how big the firm that you're asking for is. If you're asking for a smaller law firm, you might get a rate somewhere between, I would say, let's just ballpark it at $400 to $500 for a partner per hour. Right?
Well, you don't need a partner to do the setup, right?
No. They will push that down to an associate, but they're still going to be looking at it at some level.
Okay, but the guys who do the work, what would they get then?
Again, I can only speak at a smaller firm. I'll talk about the bigger firms too, but a smaller firm, an associate might be 300, might be upper 200s. Okay, but that's cheap.
Would you recommend to have a larger firm when you're setting up a company?
As I said earlier, if they're experienced startup lawyers, the work will not be different. But the connections might be different because the large law firms, those people are more well connected.
So would you recommend starting with a smaller firm, going for a bigger firm later?
No, absolutely not. Well, don't do that. Don't do that for one. Yeah. Don't ever. Like I said, choose wisely, right? Don't go with, yeah, my co-founder says, and this actually has happened. We've seen this. My co-founder, his father's brother or his uncle, he's some sort of criminal prosecution attorney somewhere, but I'm sure it'll be fine. Yeah.
Someone that's been doing startup law for 2 years is 10x better than someone that's done any other kind of law for.
Yeah, suitable. I wouldn't say better, but suitable, right? There was suitable for your situation. Law firms always tell you that they will take you in and do a transfer from another law firm free. It usually doesn't end up being free. So just understand that when you go and pick an attorney, which is why I said choose wisely, you likely are going to stick with them for a while, actually for a long time. You don't want to be in the middle of trying to close a round and have to go, oh, I need to switch. If something goes catastrophically wrong, of course, I understand, but go in there with the mindset that you are picking, you're picking someone that is going to be a longer-term business relationship for you. And so, like I said, it's comfort. Do you feel like the connections are helpful for you at a larger law firm? At a larger law firm, partners can be $700, $800, $900 per hour. The associates are going to be $500 to $600. A paralegal could run you $200 to $300. That's why we're saying if they are doing the same work, and by the way, if you ask them to set up your company, they have people manually doing what our system does. Manually, like using Word, cutting and pasting.
To be fair, I'm just trying to understand. Are you suggesting people don't get a lawyer?
No.
Okay.
No.
This feels a little bit like an ad, but I mean, feel like there's probably some good advice that people can have. I'm already incorporated, and I've done this the second time. But maybe you could tell people how to approach lawyers. So you give them a list of all the firms that are good. That sounds right. So should they get intros? How do they decide between one firm versus another? Who's a good partner to use? Should you get a more junior one or a more senior one? Maybe some of that stuff might be useful for folks in the audience.
Wow, this is a kind of different talk than I intended. Hire a lawyer.
It's legal 101, right?
Yeah.
That's I think the big thing on this is like thinking about shortcuts, how you can go there. But I think it is a really good question. Like, how do you get started? This is where I think people are getting stuck and where I wasn't sure. And I went the wrong route. So I did Fenwick and West, and I got the best partner, and it was $1,300 an hour. My investors were like, oh yeah, waste tons of money, just like go spend the money. Raise money to spend it. But like these folks more efficient. Like, how do they get started? And then I want to ask you about a trick that I don't know most people, but let's answer his question. How do they get started?
Yeah,
how do they find
absolutely.
that lawyer, that first lawyer?
How do you find the first lawyer? Well, I wouldn't recommend, what I wouldn't recommend doing is picking up the phone and calling the firms or just sending random emails. You're very unlikely to get a response. Honestly, probably the easiest way to get a contact or a name at these firms, well, look around the room, talk to this gentleman, right? Find a referral. Find a referral at these firms and say, okay, well, I've heard that firm's good, or, what firm do you use? And get a name. Get a name so that at least you start with that.
Yeah, we have. I think you built the list, but I have a list, so you can always email me and I'll send it to you. And it's the firms with the email address of the specific lawyer. And can I talk about other hacks? Can we talk about deferred payments? Because I love this because it saves people money. But
you got to be careful with it.
I'm seeing more resistance in the market to this.
Yeah, you got to be careful with it.
And just for everyone, so a lot of lawyers they're looking for deal flow. They actually will sacrifice working with you early on for free with the hope that you become a big company, and then they just hammer you with fees and they get all their money back. So what I've seen in the past is $25K of free legal help, and then when you raise your Series A or your first equity round, then you have to make payment. Does this still work, and is this something that these folks can leverage?
Yeah, there's still a fair amount of these offers floating around, right? And it can be, the number is variable, right? It's not set in stone, and the threshold is variable. It's not always if you hit a Series A. It could be a time limit, 6 months, you have to pay, we're going to start charging you. Could be by the time you raise $500,000.
Okay, so it could be a fixed amount.
Yeah.
But these folks should go to these firms when they get a referral or if they use our list, and they should ask. And how do you ask? Because this is like an awkward thing. Like, how do I not pay? How do I get help without paying you? Do you say like, how do I get on a deferred payment structure? Like, how do you position this?
I might ask Chris that, but I mean, I would just ask outright.
That's what I've noticed. It used to be 25, and I'm seeing more like 10.
Right.
Yeah.
So the amount has come down a lot. I think it's used less frequently by lawyers as a business development tool now. And to be candid, I actually, well, let me put it this way. So one thing is it is not free. It's deferred.
Yeah.
You will pay the bill.
What if you go out of business?
When.
Yeah. What if you go out of business? Then
I'm sorry?
If you go out of business, if you die, if you
that's
get hit
the
by
one
a bus,
risk they're taking. Obviously, if you go out of business, don't raise money, can't pay the bill. That's the one scenario where you don't pay. It's essentially if you can't.
Which is surprising because they're lawyers. You figure like they would go after you, but the reality is they don't. They're trying to get bigger deals. They're not going to go after you for 10K. It's not worth their time.
Anybody who's sort of made it into this is sort of part of Silicon Valley's magic is people figuring out ways to make their business work with startups, right? Landlords doing all that, and lawyers have essentially, this is their version of that really for business development purposes. Again, it isn't free, you're paying it. The other thing is there is no such thing as free. So one of the things you're doing with firms that give big fee deferrals is you are subsidizing, if you become successful and can pay your bill, for the companies that didn't, that ultimately did go out of business and didn't pay their bill. I think fee deferrals will be gone probably within the next few years. They'll be incredibly rare. The trend is they're done less frequently. The amounts are smaller, and the reality is you're not getting something for free. Really, you probably shouldn't think about it that way. And actually, the one from a founder's standpoint, I think the biggest risk really, or the biggest issue around fee deferrals is, to some extent, the way this generally works out in practice is the law firm runs up the bill to the fee deferral amount, doing a lot of times sort of stuff that could be done later, right? And so they dump all these like kind of standard stuff on you that may or may not be useful or appropriate for your business, and then you get this fee deferral, and all work stops until you can pay the bill. And so you often, the value that you get for whatever the fee deferral amount is, whether it's 10,000 or 25, I think you could discount it by, probably
50%.
half.
Yeah.
Is the real value that you're ultimately getting. So I personally tend to think fee deferrals are, they're less appealing in practice than they sound. So if you can find a way to get things going with the lawyer without a fee deferral, go for it. At the end of the day, if that's how you have to get things up and running, it's definitely out there. And any of in general, the big firms are still doing them. Most mid and small firms are not doing fee deferrals anymore. Their rates are lower. That's what they'll tell you. The one other thing is, and I don't know what you've seen, Sean, but it used to be that lawyers essentially asked for equity in exchange for the fee deferral, and that was kind of the quid pro quo. So they would say, we offer a fee deferral for 0.5% or 0.25%, something like that. That also is much less common now. Lawyers sometimes will actually invest in the company at a Series A or something. But,
yeah, that's more common. And I'm always worried about giving equity for services. If you do well, it like saves you money in the short term. But like, what if you do really well? And then if you look back on that, you're like, well, fuck, I just paid $500,000 for something I could have paid 50 for, because you don't know how that equity is going to be valued in the future. So that always concerns me.
To be honest, that whole model of fee deferral and equity with lawyers, it started 20 years ago. It is on its way out. I think it's fundamentally it's sort of a failed
Yeah, I think there's too many seed companies, too many are dying, so maybe the economics don't work. So I think what we're going to do towards the end of everything, end of day or tomorrow, we're going to send a wrap-up email, and so I'll include our list of lawyers. You're welcome to reach out to them at any time. Let's go here first, and then we'll come back over here.
Okay, so different topic, the stock plan, right? So when you're starting a company now, how large does the stock plan, or what would you expect in stock plan? How many % would you put in there? One, and the second is now you're bringing in your first key hires, first UA guy, first sales guy, first tech guy. What would you give them in terms of equity? What is the standard?
So I'll answer the first one. I'll probably turn to Chris for the second one, but companies typically will do anywhere from, let's say, 5 to 15% of their total as a stock plan. It really depends on your circumstances. And,
This you mean option pool? You'll reserve that for the option.
Stock plan, aka option pool, aka stock option plan. Yep. But yeah, somewhere in that range. Somewhere in that range.
Yeah, we are in the next one. And also, like the option pool, they're usually worried more about that towards the first equity round. An investor will force you to carve out the 15%, so it's not as critical in the early stage, just mostly because you have so much equity, like there's nothing's really spoken for. But most investors will force that in an equity round, 15%. Let's talk about, yeah. Yeah, they'll talk about that with Cap Table 101 and what they see. It is a hard question to answer because there's a lot of stuff going on in terms of, when did he or she join the business? Who else is invested? What is their role? But they'll go into a little more detail. But yeah, I know those are hard. Those I would sort of caution, like those are things you want to figure out as soon as possible. You do not want this dragging on and then your co-founder coming to you 3 months later when things are working, being like, yeah, I don't think I have enough. Like these are very tough conversations that happen all the time.
Yeah, have those kind of things up front.
Yeah, it's awkward. Okay.
Yeah.
Yep.
So with the option pool, getting back into that, with the early employees that do have stocks, are there tax implications for them? Like, do they have to pay taxes?
Are there tax implications for options?
Yeah.
That depends on how you do them. So there's a diving.
Maybe we should talk about the 83B.
We can talk about that. So essentially, there's two very simple ways you can think about this, right? There's the regular kind of option, and then there's the restricted kind of option. So the regular option is you say, I give you, the option to purchase whatever. Let's say it's 100,000 shares. And it vests, right? So you get to purchase on some schedule, and there's very standard Silicon Valley schedules for this, you get to purchase a chunk of it every month, or very standard is you wait a year and then you can purchase a quarter of it. But the very standard way to do it for kind of your employees, and I'll get to your question about the early people, is they can't do anything with it until that time hits, right? So they won't be able to do anything until it vests, which is called a release from a repurchase. Now, for founders and also for early employees, what typically happens is, the founders go, I need to own my business, right? If I gotta actually own those shares. So those are restricted shares, and sometimes, depending on who the person is and what the situation is, some key employees you may also decide to grant those types of shares to. So again, very high level. Those are exactly the same, only that you own them already. So it would be, I would, instead of giving Sean the right to buy the 100,000, I would give Sean the 100,000, right? He would buy them now, at this point in time, all of them. But I have the right to buy them back on a very similar schedule, which decreases over time, right? So very typical, 4 years, 1 year cliff, which means that he owns all the shares. I have the right to buy all of them back until a year has passed. Once that year hits, he owns a quarter of it, and then I can't buy that back anymore. And if you go that route, you will need to file something called an 83B election. If you do go that route and you need to file an 83B election, do not be late with it. You have 30 days to file it. Do not be late. You do not want to fix that.
You have 30 days from when you exercise the options. Like this is let's try and keep this like high level because it's
Yeah.
too easy to get in the weeds and I'm already a little confused and this is my job.
It's 30 days from when you either acquire the shares or you exercise for those.
And
when you
so
acquire them.
The 83B basically shields me from some tax liability in the sense where I'm only taxed at the value of them
Yes.
today, not the value of what the shares will be when they go liquid.
Yeah. There have been lawsuits about this.
But I think the short answer is like there's not really tax liability until there's liquidity, until there's cash out. But the 83B allows you to shield yourself from the massive upside there hopefully will be. Because when you exercise, you're exercising at a very low amount. The shares are worth very little, and you're not paying the premium that investors are paying. And so you can save yourself a lot of tax money. And you have to, also 83B, I think you get counsel to help you, a lawyer to help you with this. You have to do certified mail.
Oh, actually, you can do it through our system, but
big surprise.
Yeah,
Okay.
yeah.
So you
still have to mail it yourself, but you get it all prepared for you. We'll give you instructions.
Okay. But when the options are exercised, you have to file that within 30 days, and it'll save you a ton on taxes if there is liquidity down the road.
Yeah. And there's a certain way you need to send these things in. You need to. The IRS is not always good about actually saying, "Hey, we got it." So you got to prove you did it. But yeah.
Okay, yeah, because I have a bunch of those like in a drawer, the certification. So we'll see if that works.
I had wondered what happened to your previous startup. I mean, it's
other stuff. All right, let's go back here. Yeah.
All right, sorry, to keep digging into the options pool issue. So you talked about the options pool versus the rest of the company. I'm a little confused. Is the rest of the company just standard equities versus the options pool, which is reserved for options that for the employees? And what do the investors get?
Okay, so let's step back for a second, right? So right when you start your company, right, you typically only have one type of stock. An option is a right to buy that stock, right? It's not something else entirely. It's a right to do that. So what we talk about with an option pool is we're simply saying, okay, let's say we have 10 million, which is very typical for Silicon Valley startups, and we're going to make 1 million of them kind of set aside for issuance to employees, advisors, your service providers. So investors, especially early stage investors, are probably going to go in with convertible instruments, which means that they're essentially loaning you money, right? It's a convertible note or it's a convertible security, which they're kind of loaning you money without it ever getting repaid. But when they hit an event, which is usually they do a Series A, it turns into stock at that point. So that's typically how early investors do it. Later stage investors, if you hear about a Series A or a Series B, they'll get Series A or Series B stock, which is with preference.
Yeah, I was going to bring that up too. I think Capture, you guys are talking a little bit about preferred versus common. Okay. Because does everyone else understand there's sort of two classes? Investors getting preferred, employees, even founders are getting common. And so we'll talk about why.
Yep, absolutely.
Probably have a little more time for some more questions out there. Yep.
This is a bit about fundraising. So if you would say raise on a convertible note and then some point later you're going to do a follow-on round and it's still a non-equity round, is there any reason to look into like a SAFE or a KISS, or is it preferable just to stick to the convertible note?
So they're all really similar, frankly. And actually, there's a convertible note version of the KISS. So that's really a judgment call, right? Do you feel that having a different instrument would help you get money? I don't know the answer. But again, I kind of go to my consistency point, right? So maybe you update your note that you've already used, for new terms if you've gotten to a new point in the business where that might be necessary, and you say, well, kind of the same document, we can keep using it. That's a judgment call.
Can we clarify, though, that notes are done in batches, per se, where everyone comes in on the same terms?
Yeah,
and then
typically.
You're like, okay, 6 months later, you're like, oh, I got to do more notes. You would do a different note, probably with different terms.
You could use the same document, but you might have different terms on it.
Okay.
Yeah.
But can I do where one person, I give them 10 million cap, the next person I give 7 million cap, same day? Can I do that?
Technically,
do I go to founder prison? What happens?
Technically, you could.
Okay.
But
what would happen? That may make somebody mad if they will find out.
will
So if you
find
do
out.
have different valuations, at some point this all comes together and there's a waterfall. People look through how the conversion takes place, and that's where they may see that, oh wow, Bob got a much better deal than I did, and now I'm going to go run him over with my car. So that's where these situations might come. You, the founder, actually, not Bob.
Yeah. I mean,
Bob, they'll
that's,
be playing golf together and they won't care.
So again, something to consider.
Okay. So you can do that, but you run risk of pissing someone off.
Usually, you're looking at a time lapse, right? Okay, well, the notes I've raised, or the convertible securities, or the safes I've raised at the first quarter of the year. Okay, well, I need a bridge round, right? I'm going to do the same thing, but it's Q4. Okay, if your business has grown, hopefully, right, you're probably going to want to raise on some better terms, and so you want to make sure to account for that. Yeah.
So if you're on a standard vesting schedule like the one you mentioned, would you have to file the 83B within 30 days of signing your contract, or within 30 days of the one-year cliff?
I'm sorry?
For the 83B form, when would you have to send that out if you're on a standard vesting schedule like the one you mentioned?
When you get the stock. It's actually, when you actually get the stock. So if they've made an offer letter to you, but they haven't actually given you the stock, not yet. Right?
Okay,
It's
so
when
you get the actual stock certificate, right?
No.
Okay, sorry.
Yeah, and actually they don't really, you don't get a shiny thing you frame anymore. Those are those days are gone. Yeah. It'd be nice. They look cool, but yeah.
Just because I want to make sure you understood this question, I think, so getting the stock, so he's asking about vesting, how that relates to the 83B election. So you file an 83B election on shares, not an option, first of all.
Right.
So it's when you get either the founders, when they buy their shares at the beginning and have vesting, so it's shares that are subject to vesting. That's what an 83B election is for. Founders, when they buy their shares, would file an 83B election, and you file the 83B election at the beginning, right when you acquire the shares, even though the company has the right to repurchase your shares if you leave. In other words, they're subject to vesting. You file the 83B election within 30 days of acquiring the shares. So the vesting
doesn't matter.
Schedule has no bearing on when your 83B election would be filed.
Thanks for clarifying that.
I
think I missed part of that. Your question?
One here and then one here.
Could you just maybe clarify for shares that are for advisors and also for accelerators? Should that, for example, for accelerators, should it come out of that pool that's set aside? Should it not come out of that, purely out of separate investor shares? So kind of that.
So generally speaking, if you have advisors, you're going to want to issue them equity of the type of your choosing, but out of a stock plan, right? They're a service provider. You generally have a pool set aside for service providers. For accelerators, the two top ones I know of, they go for convertible. So you won't set aside things for them because they won't actually own shares until an event happens, right? Until an equity financing typically happens. So at that point, their convertible note or safe or whatever it is going to turn into shares on whatever terms are written on that document.
Yeah, but those would also be preferred shares. So the advisors
Yep.
are getting common, an accelerator would convert to preferred.
Yep.
Rather than just doing a series of convertible notes, can you not just do one and then keep extending it?
Can you do just
One note and extend it?
I guess you could, but let me just take a quick step back here, right? So there used to be this way of issuing notes where you would say, okay, I have this master agreement, right? This is my Bible of notes, and then you would use that to issue notes to people. And when you got to the end of that document, because it usually had some sort of limit on it, you might have to actually extend it. Nowadays, what a lot of people do are on standalone notes, like what 500 uses. So you don't have to actually do an extension to the notes because there's not a master agreement. Like each note that you're giving someone contains the entirety of the agreement. So you don't have to go and extend it at all. And this is very common nowadays. that answer your question? All right.
Yeah, we'll talk about it in fundraising too, though. Like, there's momentum in your business. There's also momentum in your fundraising. And so it's kind of like if this thing's like dragging on forever, it does send some weird signals. You know, it's more like, yeah, we put to get that money, and then you can also use it as a forcing function where it's like if you're trying to close that last off, it's like, yeah, we're closing this in 2 weeks. You got to jump in now. So investors are always incentivized to wait. And all I'm doing is waiting. I'm pushing people off. I'm like, yeah, come back in a month. Like, I want to see, does the business change or do you die? So if there's no incentive to move quick, they will wait. They have every reason to. Yeah.
Hey, is there any thing to watch out for foreign companies setting up a Delaware, just in general, anything that...
Absolutely. Absolutely.
I get this question all the time and I don't know how to answer it. Like, what can you, really basic high level, like what is the structure they should use? Is it the Delaware owns the international company? Is it through the Caymans? Through, like, what? How do you do this?
So, I will get to that. Let me take a quick step back, answer his question on what does he have to worry about. Yeah. You want to figure out taxes, right? You want to figure out if there's any immigration issues, should you be coming, for a program such as 500 Startups. You want to figure out if, and this is tied to the next question, you want to figure out that if you do choose a structure, like let's say you choose a Delaware C-Corporation, are there any additional documents that you're going to need because you're of your country of origin? And if you have an international subsidiaries and you want to fold those in to a Delaware C-Corporation, it's common, but this is something, it may be really, really custom. But a lot of companies do this. They have, they set up a C-Corporation and they basically have that C-Corporation own all the entities overseas. That's something you definitely want to talk to an attorney about because it depends on the country. Absolutely no idea how that could.
That's why I think it gets hard to answer because every country is different. But are you saying there's two options? I could dissolve the international company and just go flip purely into Delaware, or the Delaware could own the international entity?
Depends on the country.
Okay, depends on the country. Okay.
Yeah.
And then what is it like? What does the investor care about? Let's talk about that. Like, I think I only care about is the IP assigned to the Delaware Corp.
I think most investors.
Is that all I care about? I'm not sure. Yeah.
I think yes. And the other thing is, does the company that I'm investing in, let's just take the top level Delaware C-Corporation, does it actually own 100% of everything, including the IP? Right? Because otherwise, if, let's say it doesn't actually own those subsidiaries, well, what have I just invested in? Something to consider. Yeah. Some companies do go Cayman, right? But again, it's a question for, that one is really a question for a lawyer. Is that the right situation for you?
Sure. And then in your guys' experience in 500 startups where, you got foreign founders coming in for 3 months and potentially stay or potentially go back, what's their visa status normally? How do they normally, you see them work around those kind of things?
Yeah, you're going to have to talk to an immigration attorney.
Yeah,
I think you guys
one
have
thing,
one.
Yeah. Well, I mean, we have referrals. We don't have one on staff. I can tell you, like, our founders bend and break every rule they can to be here. And I encourage that. I mean, can we turn the camera off? But I mean, yeah, you should. But yeah, this is where, like, I don't like to give advice because I really don't know that world. Okay. But there are different ways to do it. And I know some actually get the investor visa if they have capital at home they can establish themselves with.
Okay, I've seen a couple of options. I was just wondering.
Yeah, but no, it's like, but also ours is a 3-month program and or 3.5. A lot of countries allow you to come here for 3 months, and so they go back home for a day and then they come back. Like they reset the clock. Yeah. Longer term though, you need to have an immigration lawyer that helps you get set up right.
Okay. Yeah. Yep. Sean has access to one, I believe. So.
Yeah, we have someone we refer, but yeah, that's the thing. It's just too specialized, and our batches are 50% international. So for us to do that the cost would be too much and too much for us to sort of handle. Yeah.
Just to mention, so we have an Australian company, and then we set up a Delaware C-Corp, and the Australian company owns the Delaware C-Corp. And in America, there's anti-inversion laws, so we can invert that so that the Delaware owns the Australian entity, but American law is you can't reverse that. So if you come to America and you set up shop here and you don't get the funding and you want to go back, you can't reverse it. So make sure you know what you're doing before you do it. So we're holding off until we get the investment.
That is a good point, right? Like,
I think I've heard that about Australia.
Be sure this is what you want.
The toilets spin the other way. Is that true or is that a myth? I can't remember. That is true. Okay, cool.
Any final questions? Probably have time for one more.
Let's do one more, then let's make sure we're staying on time. Yep. Go ahead. Yeah.
I know you mentioned earlier about I know you mentioned earlier about the Delaware C-Corp. That's really prevalent among investors and all. I was wondering, have you any insights about the Delaware B Corp that's kind of building up a little momentum? How is that like?
I've seen it, but honestly, I don't think investors are all that crazy about it.
I've never seen one. Yeah, can you tell us really quick what the difference is? Like,
B Corp is a for-benefit company.
Oh, okay, yeah, sorry, the social corp, yes.
Yeah,
sure. Okay.
I haven't personally actually really done much with them.
We've done one, I think. One, yeah.
But I don't know how investors would react. That might be a question for.
I think some that, especially ones that have a social mission, they're getting more comfortable with it. I can only think of one and maybe two companies that we've brought in that were a B Corp, and they were socially minded. It was recycling of hardware, computer hardware.
I want to say I know this company, but
they were one of the batches.
Me. Yeah, this is 13, right?
I think so. No, I think it was 12. But all right, let's move on. Everyone, round of applause. Thank you.